Good evening, and thank you all for joining us. My name is Avery Malinsky, and I am the president of the Northwestern Student Chapter of the Federalist Society. The Northwestern Student Chapter is honored to host the first in this wonderful series of events. For 10 consecutive Tuesday nights at 8 p.m. Eastern Time, the Student Division will host a Zoom series called Challenges to Originalism, which will feature a rotating student chapter president interviewing originalism expert Professor Strang, who will lay out 10 of the most common criticisms of originalism from both the left and the right and respond to some of the legal theory's most formidable foes, followed by a live audience Q&A. Today's challenge is Originalism is Impossible. All audience members should feel free to submit questions via the Q&A feature on Zoom. Now to introduce our Originalism defender. Professor Strang joined the faculty of the University of Toledo in 2008, was granted tenure in 2010, was named John W. Stepler Professor of Law and Values in 2015, and appointed the founding director of the Institute of American Constitutional Thought and Leadership in 2023. He was previously a visiting professor at Michigan State University College of Law. A graduate of the University of Iowa College of Law and Harvard Law School, Professor Strang clerked for Judge Alice M. Batchelder on the Sixth Circuit Court of Appeals and practiced law at Jenner and Block LLP. Professor Strang has been a visiting scholar at the Georgetown Center for the Constitution and a visiting fellow at the James Madison Program at Princeton University. A prolific scholar, Professor Strang has published dozens of articles on constitutional law and interpretation and religion in the First Amendment. His most recent book, Originalism's Promise, a natural law account of the American Constitution, is the first book-length natural law justification for originalism. He is currently editing the third edition of his casebook, Federal Constitutional Law, and finishing a book on the history of Catholic legal education in the United States. Professor Strang has lectured globally, is a frequent presenter at conferences, and regularly participates in debates, media commentary, and speaking engagements. In 2022, he convened the first symposium on common good constitutionalism at Harvard. Professor Strang, it's so great to be here with you tonight. Is there anything you'd like to say before we jump into questions?
Yeah, well, thanks everybody for hosting. I would just maybe say a little bit of background about the series, which is that originalism has been around for about 50 years now. And of course, for anybody who's familiar with the debates, there have been a lot of criticisms of originalism. And in response to that, originalism has changed significantly over 50 years. And so one of our hopes with the series is to provide some of the most common criticisms that have been articulated over that 50-year period, introduce people to them, talk about maybe who articulated those criticisms, and then some of the originalist responses to those criticisms. There's probably many criticisms that we're not going to get to. It's only 10 episodes, but our goal is to identify ones that we think are the most common and have been the most impactful in the intellectual development of originalism. So that's the introduction to the series. Thanks so much.
That sounds great. All right, well, we will go ahead and just jump right in to some questions that we've prepared for you, Professor Strang. So first, what does it mean when critics claim that originalism is impossible?
Yeah, so it's a very common criticism. It's one that's, of course, very powerful, because if originalism is impossible, then it's an empty set, that whatever it is, as compared to other competing theories of interpretation, it fails because it's not able to do the thing that it says it's trying to do. But I want to distinguish the claim that originalism is impossible, which is a very aggressive and powerful claim, from a slightly more moderate, oftentimes version of the originalism is impossible claim. And in fact, our next series is going to address this, what I would think of as a related claim of originalism is impracticable. That even if you can do it in theory, the next series episode is going to address some of the practical challenges because of the human beings who are going to do it or the context in which they're going to do it that says that originalism actually doesn't work as it's intended to work. And so the argument that originalism is impossible is the idea that even if somebody has, the best of intentions, even if they're very intelligent, even if they got a lot of time and a lot of resources to be able to work at and try to ascertain the Constitution's original meaning, it fails. That's what these arguments are getting at. So that's what it means to be originalism is impossible.
Yeah, that makes sense. Thank you. Next, we wanted to ask you, who are the key early critics that argued that originalism is impossible, and what were these critics' main arguments?
Yeah. Well, originalism's been around for a long time. There's actually a debate, right? So the debate is among different scholars, originalists, non-originalists, historians, non-historians, about what was the standard way of approaching constitutional interpretation at the framing and ratification. And the conventional originalist view, which is disputed, is that when you looked at the interpretive rules and practices at the framing and ratification, that they looked a lot like originalism. So Blackstone, who you may have read in maybe one of your property classes, or maybe in one of the cases that you've read might have been cited to him, he had these different rules of interpretation for interpreting parliamentary statutes. And when you look at them, they look a lot like the kind of claims that originalists make. But as I said, that's debated. But everybody agrees that whatever was going on prior to the New Deal, after the New Deal, and really up until the 1980s, originalism became exotic. That the Supreme Court didn't reach originalist holdings very often. The Supreme Court didn't use originalist reasoning very often. Attorneys didn't present originalist arguments very often. And so you had this long period of time where originalism was basically not a player in the debates over constitutional interpretation until the early 1970s. And the first two major originalist scholars were Robert Bork, who published an article in 1971, and then Raoul Berger, a Harvard Law professor who published a book, 1978, I believe, Government by Judiciary. And these were the first kind of modern, maybe some people call them proto-originalism. So they're not the same sophisticated version we have today, but they're looking backwards, they're looking for meaning at an earlier period of time. And so it's at that point, 1970s, that the critics of originalism first started articulating their criticisms. And for the audience, what I would suggest is there are three, I think, really key articles that are part of this criticism. So one is by a scholar named Paul Brest, and Brest argued for in an article called "The Misconceived Quest for Original Understanding." A second scholar is Ronald Dworkin. Ronald Dworkin, in my view, is one of the most powerful American legal academics in the 20th century. And he had an article called "The Form of Principle," published in 1981. And then there's an article by H. Jefferson Powell called "The Original Understanding of Original Intent." And each of these different scholars articulated a different criticism of originalism. So the Brest piece, which is a great piece, people should read it. It's in the Boston University Law Review, 1980, I think. And the Brest piece argues, among other things, that originalism is impossible because of the originalism the version of originalism at that time period was called original intent originalism. And original intent originalism was trying to, this is a very simplified version of what they were saying they were doing. They were trying to ascertain what was the intended meaning of, it could be the framers, it could be the framers and ratifiers, it could be the public as well. So what was the intended meaning? And what Brest argued was that and I think convincingly, many people think convincingly, what he argued was that there either was no originally intended meaning for some, maybe all constitutional text, or if there was an intended meaning, it in fact was intended meanings, that different framers and different ratifiers would have different intents that they were trying to convey through that text. And there's actually, which I think is true as well, another possibility, which is, and Brest argued this, maybe a lot of them didn't even have an intent, right? So when you look through the Constitution, Constitution plus the Bill of Rights, you end up with a lot of clauses that a lot of people had looked at, right? The people in the Philadelphia Convention, the people in the state ratification conventions, and it's probably the case a lot of them didn't have deep thoughts about a lot of parts of it. So you actually could have empty sets for a lot of these. So we call that criticism the summing problem, that even if there was original intent, how do you like add up different original intents to come up with a coherent conclusion? And that was very powerful. The Ronald Dworkin piece really had a different angle to it. What he described was what we call the level of generality problem, or what scholars have come to call the level of generality problem. And here's the idea behind that, that you have these different pieces of text, and they're ambiguous and sometimes vague. They're sometimes ambiguous and sometimes vague, and they could be stated at different levels of generality. So one of the examples that Ronald Dworkin used was the 14th Amendment's Equal Protection Clause. And what Dworkin pointed to was that different framers and ratifiers of the 14th Amendment had, this is, I think, probably historically accurate, but it's a claim that he made, had different intended meanings of different levels of generality for that clause. So, for example, it could be the case that one of the framers and ratifiers had a very concrete meaning, that we mean the 14th Amendment's Equal Protection Clause to outlaw the so-called black codes. And maybe that's the only intent that that person had. But maybe another framer and ratifier had a much more abstract intent, where we're committing the federal government to treating all people equally, regardless of race and maybe other characteristics as well. And so what Dworkin was saying is that if in fact these different levels of generality existed in people's mind, then originalist judges actually have a choice to decide which one. And so originalism isn't a thing there. It's actually continuing to be a choice, just like living constitutionalism. And then the third article, the one by H. Jefferson Powell, The Original Understanding of Original Intent, what he argued was that originalism is actually inherently contradictory. And Powell's piece, very influential. And what Powell did was he went through the history and context of the framing and ratification, and he looked at things like Americans during that time period were primarily Protestant Christians who had a reverence for, a following of the text, and were really skeptical of non-textual interpretations of text. And then he also looked at some of the practices. I mentioned Blackstone earlier. He looked at some of the practices about how people interpreted laws at that time. And his claim was that in the framing and ratification period, original intent was not the way Americans interpreted the Constitution. And so originalists in the 1970s and 80s were actually doing something inconsistent with the originally intended meaning of the Constitution. So those I think are the three main originalist critics in the time period, and those are the three main arguments.
Sounds good. Yeah, we've gotten some great questions from the chat, and
Okay.
Everyone participating. We'll definitely come back to those at the end. But Professor Strang, I wanted to give you the chance to explain how originalists responded to these criticisms, these early criticisms of originalism.
Yeah, well, good. It's good to hear that there's questions. It's good to be provoking thought and conversation. So the main move, there was a main theoretical move, is what I want to try and describe. And actually, a number of people contributed to it. Justice Scalia, I think one of his main contributions to legal theory, and many of them, was the move from originally intended meaning to original public meaning. And so this theoretical move towards original meaning was one of the main ways, I think probably the main way, the main conceptual evolution that helped, from originalist perspective, helped respond to and overcome, maybe even eliminate those previous criticisms. So what does it mean to be a public meaning originalist? Now, and I just want to bracket, there are other kinds of originalism out there. This is not any way meant to say that they're not viable. And in fact, if we can, I'd like to come back to original intent at some other point. So the public meaning is meant to be the public meaning of the text at the time that text was ratified. And the public meaning has three basic inputs into it. So one is the conventional meaning of the words. So think about the Commerce Clause. The word commerce, we use it today, but it was also used back in 1789. And so what originalists would do is they would try to find out, was there a conventional meaning of the word commerce? And in principle, you could look through all kinds of different sources of information. You could look through the Philadelphia Convention, of course, but you could also look through the state laws at the time period. You could even look through private letters, right? Because the goal is, somebody who's facile with the use of American English at that time period, what was the conventional meaning of the word that they were using, the word commerce that they were using? So conventional meaning is the first element. Second is syntax and grammar. So it's the word put into the context of a document, which has a clause, a sentence, a paragraph, and then the broader document. And then lastly, which modifies the meaning and actually gives clarity to the meaning as well. And then third is something called contextual enrichment. And this has really been a more recent move, so it's a little bit of looking forward past the 1980s. And the idea of contextual enrichment is that when it comes to effective communication, the person who's the author, so the drafter, the writer of the written text, needs to know that the reader, so it could be a ratifier in a state ratification convention, it could be Americans today, right? In 2024, I was going to say 23, 2024, and so both parties need to have additional information about what the context was at that time period. So an example would be the free exercise clause. That one part of the context of the free exercise clause was that Americans, of course, were familiar with many religious traditions in 1791 when the free exercise clause was adopted, primarily from the Western tradition, but also non-Western religious traditions as well. And so that gives us a knowledge about their conceptual space, like how broad and varied might the word religion have meant to them. So that's original public meaning. How does it respond to those criticisms, right? So the summing problem. So we're not actually summing private intents anymore. Framer intended meaning, it's evidence of the public meaning, but what we're looking at is conventional meaning, syntax and grammar, and public context. And if you think about the data set, Avery, the data set, as I said earlier, in principle means we can look at any usages of that text of that time period to get towards that data set. Remember the generality problem? So the level of generality problem. This was addressed, I think, best initially by an article by Keith Whittington in, I think, 2003. It was called The New Originalism. And as a part of that article, Professor Whittington was talking about the response to Professor Dworkin's summing level of generality problem. And what he argued was that the original meaning itself determines the level of generality, that there's not some kind of mysterious multiple public meanings floating around, or at least not typically, maybe there are a few, but that when you do the research of the original meaning of a clause or a provision, what you'll find is that original meaning comes in different packages from very rule-like to something very, very abstract. I'll actually give you two examples. So one is the Equal Protection Clause of the 14th Amendment. That was Professor Dworkin's main example of a very abstract clause. But the scholarship by Professor Christopher Green in a couple of articles in the George Mason Civil Rights Journal, go read them. They're very long, they're very detailed. I think they convincingly make the case about what the public meaning of that clause was. And it wasn't necessarily a rule, but it was not an abstract principle either, and certainly not an abstract principle of equality. What it said was that the law enforcing and law applying institutions, the executive and judiciary, have to be open to all citizens, all people, on an equal basis. In other words, they can't be excluded based on race. And that's, again, that's not a concrete rule, but it's also not an abstract principle. And where Professor Green made that argument was, he said, looking at the history, the context, the conventional meaning, the grammar and syntax of the clause, that was the conclusion he came up with. And then another example would be the original meaning of the word cruel. So the original meaning of the word cruel, I think, was best articulated by Professor John Stiniford from Florida. And what Professor Stiniford argued in a very detailed, powerful article was that the original meaning of cruel was disproportionate to the crime. And that is an abstract principle. So it's supporting Professor Dworkin's point in some way, but the way we know that is by looking at the original meaning of that text. And then the last criticism, remember, was the inconsistency criticism, that original intent is not the original intent of the framers and ratifiers. And what scholars have argued, and I think Professor Barnett did this the best initially, and maybe still today, in his book Restoring the Lost Constitution, where he goes back, and when you look at actually Powell's article from 1985, the original understanding of original intent, what you see is that what Powell was arguing for is what people today call original meaning originalism. That he was saying that both the context and the practices were actually originalist practices. So the move to original meaning either eliminated or at least really reduced the power of those criticisms.
Yeah,
so I think that's the way to think about that.
Yeah. Has that change to original public meaning been effective in defeating those first prominent objections to originalism?
Yes, and so I gave some examples about why those three initial criticisms are no longer, at least in my view and most originalists' view, powerful. There's actually been a couple of other developments as well that originalists have used that I'll mention here. So one of them is the idea of constitutional construction, and I don't know if it's something that's come up in your law classes. I think it's something that probably most of us have bumped into, even if we haven't seen the label. And the idea behind constitutional construction is actually pretty intuitive. It's that there are times where the Constitution's original meaning, it gives us one right answer. And an example would be, can Congress regulate the commercial transportation of goods on trains across state lines? The original meaning of the Commerce Clause clearly says yes. But there are also times where the original meaning is underdetermined. Now, it's a term of art. What it means is that it's not like radically indeterminate, but it's also not fully determinate. There are some areas of vagueness and ambiguity that exist. And so in those areas of underdeterminacy, what originalists argue is that we're in the zone of constitutional construction, where the relevant interpreter actually gets the ability to create, to craft, to construct constitutional meaning. Now, there's debates among originalists about who does that. So some originalists argue that it's the judiciary that should be doing that. Some originalists argue that it should be the elected branches. That's my position that I argue in my book. But regardless, the idea is that everybody agrees that at some points, the original meaning becomes underdetermined. Now, if that's true, what that means is that, remember those three arguments that we talked about earlier, especially the first two, the idea of the summing problem and the idea of the level of generality problem, even if the move to original meaning didn't totally eliminate those arguments, what the idea of constitutional construction does is it says, okay, even if it still remains in some way viable, that there's some areas where the level of generality isn't determined by the original meaning, and that probably exists, the originalism has a response to that, and the response is that the relevant interpreter should construct constitutional meaning. So the idea of constitutional construction, I think, was another real important addition to the repertoire to help respond to those criticisms.
Yeah, that's really helpful. I wanted to get at least one more question out on the table before we begin to respond to some audience questions. So
Sure.
I was wondering, what are some of the more recent ways in which scholars have rearticulated the claim that originalism is impossible?
Yeah. So let me say just a couple of things. There are lots of good works of scholarship out there that make this claim in one form or another, and I've tried to capture most of what they argue. A recent book is by Dean Erwin Chemerinsky, Worse Than Nothing, where he makes a number of these kind of arguments. Another book is by a great scholar, Eric Siegel, a good friend, who in his book called Originalism as Faith makes some arguments of impossibility, and I'm actually going to treat most of them in the next episode as arguments from impracticability. So I don't want to try to minimize the really great work that's being done out there. But the piece that I've actually found that's most powerful recently is an article by Richard Fallon in 2021 called The Chimerical Concept of Original Meaning. And so Professor Fallon's article, very detailed, is a little bit in the weeds, honestly. It was published in 2021 for those who want to go out and read it. And Professor Fallon argues, this is a really complex argument, kind of simplified. What he argues is that originalists like I have been doing claim that when you look at the linguistic facts of the world, when you look at conventional meaning, syntax and grammar, publicly available context, that factual evidence determines what the original meaning is. So it's a factual claim, not a normative claim, that it should be this or should be that. That's nothing I've said. My claim is that that's factually what the case is. And what Professor Fallon does, very sophisticated, is he says that at one of those steps, remember I talked about the publicly available context? What he argues is that in the US constitutional context, the evidence that's available in the publicly available context is too thin to provide enough evidence to identify what the original meaning is. And so if that's true, in other words, if we've got just the conventional meaning, and if we have grammar and syntax, that's going to allow, and not much public available context, that's going to create a lot of ambiguity and vagueness, and going to create a lot of underdeterminacy. And so if that's true, it doesn't totally destroy originalism, it doesn't totally make it impossible. In other words, it's a more measured argument than the earlier ones we talked about, but it is still a very powerful argument, and on originalism's own terms. That's one of the things why I like about it. It's just a really powerful piece. Now, originalists, I think, have two basic responses to that argument. One response, published by Professor Solem, who I think is the most articulate originalist writing scholarship right now, in a piece called The Public Meaning Thesis, published in the Boston University Law Review, I think maybe a year ago. He responds in two ways. One way is he says that, in fact, there is enough evidence in the publicly available context for us to know, in most cases, what the original meaning is. And there's one way that actually all our audience can test that, right? So what our audience can do is they can, let's pick the Commerce Clause, right? So the Commerce Clause was drafted in secret. This is one of Professor Fallon's arguments. And we don't know much about the people who drafted it. I'm sorry, the audiences don't know much about the people who drafted it because we have hypotheses of who actually did the drafting. We don't know, and certainly the people initially didn't know much about what the reasons were for adopting the Interstate Commerce Clause. So this, I think, is a good example of Professor Fallon's argument. And what you can do is the audience can go and read some of the scholarship on the original meaning of the Interstate Commerce Clause. What I would suggest actually are two pieces of work. One is an article by Richard Epstein. It's about 25 years old now, called Commerce, Virginia Law Review. Second is a chapter in Randy Barnett's book, Restoring the Lost Constitution, on the original meaning of the word commerce. So read that yourself, look at the evidence that they provide, which includes the publicly available context, and then decide for yourself whether you come away confident that you've had enough information to make that decision. So the second response actually draws on some excellent work by a scholar from England named Richard Eakins. Richard Eakins recently published a book called The Nature of Legislative Intent. And what he does is he actually kind of takes head on the summing problem that we talked about earlier. And so Richard Eakins is one of a kind of a revival of original intent originalists. Now, I'm not saying Eakins is an originalist, but his work has been relied on by originalists. In particular, Donald Drakeman wrote a book 2 years ago, published a book 2 years ago called The Hollow Core of Constitutional Theory, where he relies on Eakins' work to try to rejuvenate original intent originalism. And it's a complicated argument. The way to think about this is that for both Eakins and Drakeman, what to think about is when we have legislatures, the legislators themselves will have individual intents, right? I intend the Free Exercise Clause to mean this. But what the move by Eakins and Drakeman, and also Solem as well, is to say, do they also have what the scholars call secondary intents or second order intents? And the second order intent is the rules governing what we do with our first order intents. And so let's say that, which I think is a reasonable proposition, let's say that legislators in the legislature, so the Philadelphia Convention, the current Congress, that one of their second order intents is that the meaning of the statutes passed or the constitutional provisions passed would be determined according to the public meaning of that text. Now, my view historically is that in fact was the case. That's what originalists argue. And so if that was the second order intent of the folks in Philadelphia, then we don't have a summing problem. And we do have a form of original intent originalism, one I think that is compatible with original meaning originalism, where we're looking at the second order intent, which tells us to look at the public meaning of any of the clauses, regardless of what any framer or ratifier had in his or her own mind about, let's say, commerce. So I think the Fallon piece is maybe like a really powerful updated version. And then I gave you a couple of originalist responses to that, Avery.
Yeah, on the subject of original intent, we had an audience member ask whether Bruin is an example of original intent originalism, if that's something not much about.
Yeah, great question. So a way to think about original intent originalism is that what we're focused on is what was the intended meaning either by individual framers and ratifiers or more likely by a group of framers and ratifiers. And so an example that I used, just because I'm familiar with it, is James Madison was the author of the text that was introduced into the first session of the first Congress that became the Free Exercise Clause. And an original intent originalist would ask, what did he think the meaning of that text was? And in fact, Madison helpfully had a maiden speech where he tried to articulate what that was. So that's an example of original intent originalism. Now, what's Bruin doing? So Bruin is the recent case, I think a year and a half ago now, where the Supreme Court was interpreting and applying the Second Amendment and was facing a challenge where the Supreme Court in Heller back in 2001 or so, 2004, had interpreted the Second Amendment in accord with its original meaning to provide protection for an individual right to keep and bear arms. And the courts, the lower courts, have been implementing that with kind of some standard tools, some standard non-originalist tools actually, of different versions of something like intermediate scrutiny. So what Bruin did was, it's actually a super fascinating topic. What Bruin did was it said, what we're looking for is whether or not any particular gun regulation today is consistent with the history and tradition of analogous gun regulations in the early republic. Now, I don't think that's original intent originalism. It's not. There's a debate among originalists what it actually is. I think the best piece so far on that is a piece by Randy Barnett and Larry Solom that tries to talk, that is talking about the role of history and tradition in Bruin and some other cases. So go read that if you want to, I think, get the
In Northwestern's law review.
in Northwestern. That's right. Yes. Which always publishes excellent scholarship, including a lot of great original scholarship. There's actually an article, just one kind of side note, 1987 by Richard Kay, 3 objections to original intent. And it's just a great piece. Northwestern published it now almost 30 years ago. Okay. So what I think what Bruin is doing is Bruin is saying we've got the original meaning of the Second Amendment, and how are we going to operationalize that? This intermediate scrutiny stuff isn't doing it for a variety of reasons. And what you can think of is as if the history and tradition of gun regulations contemporaneous with or around 1791 are what Bruin is looking at, or maybe 1868, because it's also dealing with the state. So I think there's a question about, are we looking at 1791 and or 1868? And if that's what the court's looking at, contemporaneous with ratification, that's an original meaning project, right? Because what it will be saying is that part of the publicly available context was the understanding that having a right to keep and bear arms doesn't mean you can do anything you want with it. It means that you have the right to keep and bear arms consistent with the practices of the American people at this particular time period. So I think if Bruin's an originalist decision, I think the way to think about it is the history and traditions are evidence of what the original meaning was at that time. So I think that's how I currently look at it. Although it is, I think, if somebody's looking for a law review note or paper to write, I think what Bruin means is a really intriguing possibility.
Definitely. Well, thank you so much for all the audience. Thank you so much for coming. And Professor Strang, thank you so much for taking the time out of your evening. I think we are just about 1 minute over time right now. So I encourage all of you to tune into next week's Challenges to Originalism session. And those questions that we didn't get to this week, I'm sure will continue to be relevant. Like Professor Strang mentioned, next week when we talk about the criticism that originalism is impracticable. So thank you all so much again, and good night. It was great to have you here.
Sure. And I'm happy for people to email me questions if they want to as well.
Great. All right.
Yeah,
Thank
thanks,
you all
Avery.
so much.
Great conversation.